Please get ready for a dictation of exercise number 25. It is a legal passage from Progressive Magazine of June 2022. 5 seconds. Start. Learned counsel for the appellants would submit that there has been no fundamental breach of the policy conditions. In this context, we may profitably refer to the decision in C. Bharatha Ma, wherein a two-judge bench squarely dealt with the absence of a permit and ruled that plying a vehicle without a permit is an infraction and insurer is not liable. In Lakshmi Chand versus Reliance General Insurance, the court was concerned with an order passed by the National Consumer Disputes Redressal Commission that had declined the relief to the petitioner therein. The insurer in the said case had taken the plea that the complainant had violated the terms and conditions of the policy, for 5 passengers were traveling in the goods carrying vehicle at the time of the accident, whereas the permitted seating capacity of the motor vehicle of the appellant was only 1+1. The two-judge bench referred to Oriental Insurance Company Limited versus Meena and others and expressed the view that in order to avoid liability, the insurer must establish that there was breach on the part of the insured. The obtaining fact situation is sought to be equated with the factual score in the said case. In this regard, it is useful to refer to the bench decision in HDFC Bank Limited versus Reshma and others. The issue that arose before the court was whether the financier was liable to pay the compensation or it was the liability of the borrower. The tribunal had returned the finding that the duty of the financier was to see that the borrower did not neglect to get the vehicle insured, and therefore it was jointly and severally liable along with the owner. The High Court had concurred with the said conclusion. The court referred to Purnia Kala Devi versus State of Assam and other that has dealt with the definition of the term owner as contained in section 230 of the Act. In the said case, the vehicle in question was under the requisition of the state of Assam under the provisions of law. In that context, the court has expressed that the High Court failed to appreciate that at the relevant time the offending vehicle was under the requisition of respondent state of Assam under the provisions of the Assam Act. Therefore, respondent was squarely covered under the definition of owner as contained therein. Here, the legislative intention in including in the definition of owner a person in possession of a vehicle either under an agreement of lease or agreement of hypothecation or under a hire purchase agreement to the effect that a person in control and possession of the vehicle should be construed as the owner and not alone the registered owner. The High Court further failed to appreciate the legislative intention that the registered owner of the vehicle should not be held liable if the vehicle was not in his possession and control. The High Court also failed to appreciate that Section 146 of the 1988 Act requires that no person shall use or cause or allow any other person to use a motor vehicle in a public place without an insurance policy meeting the requirements of Chapter 11 of the 1988 Act, and the state government has violated the statutory provisions of the 1988 Act. Be it noted, in the said case, the liability was fixed on the state, keeping in view the legislative intention behind Section 146 of the Act. No person shall use or cause or allow any other person to use a motor vehicle in a public place without an insurance policy, as that is the mandatory statutory requirement under the Act. Emphasis was laid on possession and control of the vehicle, and accordingly liability was fixed on the state of Assam. In HDFC Bank Limited, the 3-judge bench opined that the hypothecation agreement did not convey that the appellant financier had become the owner and was in control and possession of the vehicle. It was the absolute fault of the respondent number 2 to take the vehicle from the dealer without full payment of the insurance, more so when nothing had been brought on record that the said fact was known to the appellant financier or that it was done in collusion with the financier. The court held that when the intention of the legislature is quite clear to the effect that a registered owner of the vehicle should not be held liable if the vehicle is not in his possession and control, and there was evidence on record that the respondent number 2 plied the vehicle without the insurance in violation of the statutory provision contained in Section 146 of the Act, the High Court could not have got the liability on the financier, and finally the financier was absolved of the liability. In the case at hand, it is clearly demonstrable on record that the vehicle at the time of the accident did not have a permit stop.